We did
Court does call the
review
case
the
People
pre-sentence
versus
reports
Desir
on both
Sanders.
cases. We don't have any material changes, additions, or deletions. On the misdemeanor case, we are asking for credit for time served. I did review that case with Mr. Bond Sanders. Both he and the victim in the case deny that anything physical happened. I know he has been in victim wants to custody for some time. I did speak with Ms. Pilara, leading a domestic violence course. You finished the domestic violence course? So he has done some improvement, self-improvement while in custody, and I hope the court take that into consideration on that case. Regarding the other case, we are asking that you adopt the probation recommendation. Mr. Bond Sanders has been wonderful to work with. He's been very attentive and taken these matters seriously, especially after the bond violation, as the court knows. Every conversation that we've had with him has taken responsibility for his actions. He would like contact with the victim in this case. They do have a child together. However, he did say that if the court does not grant contact, he does have a place that he would stay that's separate from her and would comply with any conditions the court orders.
All right. Before I hear from the defendant, do people have a position on the contact probation?
Yeah, this time I would be objecting to the contact. We would like to see how Mr. Bond Sanders does on probation. Maybe this first review need to be addressed because there was serious, at least the one case I do agree is a serious case, and I would have concerns. I don't know, that you addressed.
In this tense courtroom, a defendant begged the judge to allow contact with the victim so he could see his child. But the prosecution pushed back, pointing to a history of violence and broken trust. After reviewing the case, the judge shocked the room with a strict ruling: no contact, probation terms extended, and bond left untouched. The message was clear. The court put safety first.
I wouldn't object to defense's request. I believe they had the same terms of probation as well as the like. So,
if I don't order contact, let's say I follow the people's recommendation. How old is your child?
He's 1. He'll be 2 in October.
Pardon?
He's 1. He'll be 2 in October.
Okay. So, would there be a way for the two of you to arrange so that you can see your son?
It's possible, yes.
Pardon?
It's possible, yes.
Okay. All right. Okay. Sir, anything you want to tell me before
I just want to apologize for my actions. I've been taking classes. I've been thinking for a change, anger and management, a couple domestic violence courses. Just trying to better myself and get myself back on the right track where I need to be, where I should be. Just trying to do something right for my kids. Even took the parents in class while I've been in here. Just trying to man up and get this over with. That's it. That's all.
And what's the major reason you had to do better?
Not for myself, but at least for my kids.
Yeah.
My kids need me. I have 5 of them. They are looking up to me. So.
In case ending in 933, domestic violence case, 24 months probation term, $555 fines and costs. That will be due 60 days after release. I'll waive probation oversight fees on that case because I'm going to get to them on the other case. Comply with all the terms that I will announce in 24 F10803. I'll set a review hearing on this case. That's to be held October 20th, 2025 at 1 p.m. I'll order 93 days of jail, credit 53, and the balance on that case is suspended. In the other matter, on 24 months, $555 fines and court costs, $720 probation oversight fees. Such on a payment plan as arranged by probation for those things. You understand that, sir?
Yes.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. Will be subject to random testing as directed by probation. You are to complete a domestic violence program as directed by probation. I am going to continue at this time the no contact with Ms. Henderson Okay, now going to the residence employment of Miss Henderson. I am, however, in this going to make an exception except for child exchange, but I'd prefer that be done through a third person.
Yes.
Okay.
I can do that. Yes.
So except for child exchange. So if it's something having to do with the child, you can have contact, but you have to make sure you can verify that. You understand me?
Yes.
Okay. There should be no assaultive, threatening, or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to report to probation on August 20th, 2025 at 10:30 a.m. That's an in-person meeting. Then you're to report as directed. I'll set a review hearing that's to be held October 20th, 2025 at 1 p.m. I'll order 93 days in jail credit, 53 days. The balance is suspended. What's your child's date of birth?
October 19th. That's what I was just gonna ask you. You got it.
October
Can
19th.
we do it like a little sooner? His birthday's.
Well, I can't do it sooner because of the court scheduling. Ms. Valera, if he is doing otherwise, okay, then get a report to the court around the 18th or sometime around then, and we'll see about lifting no contact provision so that he can celebrate his child's. The child will be with his parents on his birthday.
Okay, and I'll
Right.
discuss that with him a little bit.
All right, very good. Okay, thank you.
Did you ever anything about the other case at all?
I'm working on it.
Court does call the case People versus Tausfet. Is it Araya?
And on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Araya. Mr. Araya, please state your name for the record. We're asking for an adjournment to the next possible date. There's some bond issues that I'm hoping to work out with the people pertaining to the no-go to and whether the alleged victim is still present at the home.
Got it. My next day.
September 8th at 1 p.m.
During this matter to September 8th, 2025, 1 p.m.
Thank you, Your Honor.
Thank you. Bond continue.
Okay.
Court calls the case People versus Arande C. Jones.
Ally's on behalf of the people.
Good afternoon, Rob Jekyll on behalf of Mr. Oronde Jones.
Your name, sir?
Oronde, last name Jones.
Your Honor, can we briefly approach on this matter, please?
You may.
My understanding today's time and day for a pretrial in this matter. Judge, I'm wondering if I could make a bond motion before we set any dates.
Yes, go ahead.
Just basically, my client's never been in trouble before. He has no criminal history whatsoever, no juvie, no adult. He is let me get this straight, sewer and drain maintenance person working for Hoover and Troy. He has a valid license. If the court were gracious enough to put him out on tether, he could be tethered at 8674 MacArthur and Ypsilanti. One of his best friends is willing to take him in. He will not contact the victim. It's my understanding the victim wants to contact him. I met with Oronde earlier this morning. We went over the police report and the allegations she's making, not only to this case, but in the past, he claims are just outrageous. I understand the victim may have a different perspective of that, but all that being said, Judge, he's on a $25,000, 10% bond. Judge, we're asking if the court would consider a PR bond on tether or a nominal cash bond. He will not contact the victim. I told him if he does, it's just going to lead to further problems resolving this matter. But at this point, we would ask if you would consider that tether release.
Your Honor, I would be objecting to any modification of bond at this time. This case involves serious allegations of argument that became physical when she smashed her phone, grabbed her, and threw the victim down on the carpet, then got on top of her and tried to strangle her twice. She was able to defend herself and get him off of her. She then tried to scream for help, and he put his hand over her mouth and pushed her back to the ground. When officers arrived, she had laceration to her neck, redness on the right side of her upper lip, and carpet burn. He also has a dismissed DV from 2021 out of 1482. So given this and the facts in the police report, I would be objecting to any modification of bond at this time.
Just very briefly, Judge, when he will acknowledge that when he kind of got mad, he threw the phone down. It cracked. I mean, he didn't do it to do it, but his action caused the phone to crack. Again, there was some tussling in the room, but you read the police report and it looked like World War III, and he said that's not what happened. And again, I'm asking, because he has no criminal history, he's a productive citizen, we're asking that the court please consider a bond reduction.
What are you asking to do with this case? And then I'll roll on bond.
Judge, I got to advocate on behalf of my client the best. He's telling me that again, if it were just a plead to the phone, I would plead him up in 30 seconds. The domestic violence charge, again, as I explained to the court, this couple has been going on for 10, 12 years. I don't know what's going on between them, but again, it doesn't seem like there's a history of violence between these two people. And I believe what my client's telling me, which obviously is opposite what the victim's saying. I believe she's here wanting to have contact with him. I told him if that happens, he'll probably end up in jail if you were to release him again. He should have no contact with her. So the domestic violence case, he doesn't want to plead to that. So I guess we're setting it for a jury trial.
And I did just want to note for the court, the dismissed case from 2021 was with the same victim.
All right. It's a jury final settlement conference for October 17th, 2025 at 9 a.m. Jury selection in this case will be set October 20th, 2025 at 8:30. Both of those proceedings are in person. What I will do with reference to the defendant's bond, I'm going to deny the request for change in bond. I'm not going to change his bond nor the conditions, particularly regarding contact. He was arraigned 5 days ago. However, Mr. Killowald, I will set a bond hearing. My next one's September 8th.
Yes.
I'll set a bond hearing to review that bond so he doesn't sit until October. I'll set that for September 8th, 2025 at 1 p.m. And that way, at least, we'll be getting close to an adequate period in time between the time of his arraignment.
Judge, can you give me the final settlement conference date again? I'm sorry.
October 17th.
Final settlement conference, October 17th. You understand that?
Yes.
Okay, thanks, Judge. We appreciate your consideration.
Thank you.
But it's my understanding, I know you don't have any authority over the victim, but if she's trying to contact him or visit him at the jail, he just needs to refuse those contacts for now?
Yes, you're going to be the one, so that you understand entirely. Part of my rationale also is
a domestic violence case took a dramatic turn when the defendant pleaded for a chance to reunite with his family. He promised he'd change, taking classes and working on himself. But prosecutors reminded the court of serious past allegations. The judge listened carefully, then denied his request, ordering no contact except for child exchanges.
We're out. Something's going to occur not gonna attribute who it's gonna be,
Right,
but I don't have jurisdiction over her.
right.
If there were contact, even if you were trying to get away from it and you're there, you're the one that's gonna be taken in.
Oh,
And I think what Mr. Killawald was indicating where he said I'll just say it because he said it on the record, he expressed concern that if there was contact and you were out, as he's probably told you, you're going to be the one ending up back in. And then that's a higher mountain for you to climb because now not only do I not have you abiding by those conditions, now that I don't have you abiding by those conditions, I then have a bond violation, and then it becomes a much more difficult task to let you out.
well, I definitely wouldn't violate.
No, that's okay.
Right.
We're good. Judge,
Okay.
one last,
And so what I did, and also I'll just point this out, I normally don't set a bond. If you set it for jury, I normally don't set a bond hearing. I'm doing that so that I want to make sure I take a look at it before it just strolls into October.
Judge, I need to file a bond motion, correct, for the,
Pardon?
you want me to?
No, that's why I gave you the date so that there was no necessity of that.
Okay,
No necessity for you to file a bond motion. I understand the issues involved. I mean, if you want to file something, you can.
No.
But I've given you a date so that it will be heard. He's just not sitting.
and with your knowledge and background, I didn't think I need one. Thank you, Judge, very much.
Kilowatt battery will get you everywhere. All right, thank you.